flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Except for Flanders.
First item tonight is it's the first meeting after the first of the year. We need to elect a chairman and vice chairman. Are there any nominations for chairman?
I'd like to nominate George Hamner as chairman.
Second.
Third.
All those in favor say aye.
Aye.
Opposed? Thank you. Like signs. We need a vice chairman. Those nomination on vice chairman.
I'd like to nominate Craig Fletcher as vice chairman.
Seconds.
Third.
Fourth. Second. Those in favor, please say aye.
Aye.
All opposed, like sign. I've got an appointment tonight, so I'm going to have to leave. The vice chairman can take over.
I don't think so.
First real item tonight, no levity, all levity aside. First item is the approval of the minutes from December 13th meeting. Anybody want any additions, deletions? If not, we need a motion to approve.
Move to adopt as presented.
Second. Greg. All those in favor say aye.
Aye.
Like sign, opposed. Passes unanimously. We have one item on consent. It's the RCMA daycare facility. Does anybody care to pull it?
I had a question for staff, but only one question. I don't need a presentation, so could I just pull it for one question?
You may. Any time for the question.
Oh, okay. Hello. Anybody home?
I hope the rest of y'all are a little quicker tonight than
This, when the road is paved up there, you're telling us here they don't need a pull-off, a slow-down lane, right? But you didn't say that they won't require one when the road is paved either. When it does come up for repaving and widening, will you look at that again, or?
Well, it'll be considered in the design. This is going to be a 4-lane divided roadway. That's the section, so there will be a median. And during design, the designers will look at where it's appropriate to have median cuts. And there probably won't be one here for the daycare, so it'll probably be a right in and right out.
So you're going to take away probably 30 feet of their frontage there anyway, and then.
Actually, yes, they have already entered into an agreement with the county for the purchase of the right-of-way. Okay. And as you saw in there, we're deferring the sidewalk requirement, and that'll be built with the roadway construction, and the applicant will have to pay for the cost of that.
Okay, so we're not planning on a turnoff. Okay, thank you, Mr. Chairman.
Any other questions? If not, we need a motion to approve the consent agenda item.
So moved.
In favor?
Second.
Aye. Got a second? All those in favor say aye.
Aye.
Opposed, like signs. RCMA daycare facility requests administrative permit approval for a preschool daycare facility to be known as RCM Daycare is approved. You can take the rest off the minutes off the sheet. The next item is listed as a public discussion. It is quasi-judicial. Anyone who is going to speak needs to be sworn in. So if you please stand with your right hand and be sworn in to make testimony.
Would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? Okay.
This is an appeal of a decision by the community development staff to deny the request for a 1-year extension of a site plan application to construct a concrete batch plant. We need for everyone to understand exactly what we are doing tonight. We see people in the audience. This has been very controversial. And if I could, George, would you explain the points of order, please?
Sure. Thank you, Mr. Chairman. The appeal before you tonight, as you stated, relates to whether staff, as a matter of law, improperly denied appellate's request for a site plan extension. This appeal is narrow in scope. This appeal does not rest with questions of merit. Whether this is a good project or not is irrelevant. Such testimony is irrelevant. The Land Development Regulations, Section 902.075, provides guidelines for the Planning and Zoning Commission review of this appeal. Staff will address these issues, and it is for this commission to decide whether staff followed the code correctly and denied appellate's request for a site plan extension. If this commission does reverse staff's position, that does not mean that the site plan will be approved. It just means that the site plan would go forward for review. So it's very important that we make that distinction. This is strictly for whether the site plan extension should have been granted. And Brian is going to provide you with some information.
Is there any, George, so everyone knows, is that in the appeal process, when we go through items, normally if something happens here, it moves to the Board of County Commissioners. Is this appeal stop here, or does it move ahead to somewhere else?
This could be the final jurisdiction to hear the appeal unless it is taken up to the Board of County Commissioners. So it could be the final, or if it is appeal from here, it would go to the Board of County Commissioners.
And the party can continue to do that?
Yes.
Okay. Brian, go ahead, please.
Thank you, Chairman Hamner. My name is Brian Freeman, Indian River County Senior Planner. And the appeal under consideration tonight is an appeal of a decision by the Community Development Director to deny a request for a one-year extension of a major site plan application to construct a concrete batch plant. And what we'll do here is just kind of look through the timeline of the application, or actually applications, I should say. There was the first site plan application that was submitted by Ocean Concrete was turned in on November 15th of 2005, and that application was reviewed by the Staff Technical Review Committee on November the 30th of 2005, and following that meeting, the Technical Review Committee, or TRC, issued a formal discrepancy letter on December 5th of 2005. There was no response by the applicant to that discrepancy letter, and after 12 months, the first site plan application expired, and it expired on November 15th, 2006. The section of the Land Development Regulations, or LDRs, that addresses the expiration of site plan applications is 914.06(4)C, and that section states that all applications shall expire and become null and void if approval is not obtained within 12 months from the date a complete application is received by the Planning Division. And based on that section, that is why the first application expired in November of 2006. Following the expiration of the first application, the applicant submitted a second application on December 6th of 2006, and that second application was reviewed by the TRC on December 20th of 2006, and following that meeting, a formal discrepancy letter was issued on January the 2nd of 2007. The applicant responded to the comments in that discrepancy letter and also requested a one-year extension, and that occurred on November the 21st of 2007. Following that response, staff reviewed it and issued a second discrepancy letter on December 4th and also denied the extension request. On December the 6th, 2007, the applicant resubmitted again, and staff reviewed that and issued a third discrepancy letter on December 17th, 2007, and also advised the Ocean Concrete applicant that the application had expired because 12 months had passed since the original application was submitted and no approval was obtained. Something else that also occurred during 2007 was amendments to the Industrial District Use Regulations, and an ordinance was adopted by the Board of County Commissioners on July the 24th of 2007, and that ordinance essentially restricted heavy process uses to the IG, or General Industrial District, only, and those uses were thereby prohibited within the Light Industrial, or IL District. Of the affected uses were many, but these included concrete plants, paper mills, and also brick tile factories. As I previously stated, a request for a site plan extension was submitted by the Ocean Concrete applicant on November the 21st, and on December 4th, the Community Development Director denied that request because the proposed use, being a concrete batch plant, was no longer permitted within the IL district. And regarding site plan application extensions, the relevant LDR section is 914.064D, and that section states that upon finding of good cause, the Community Development Director may grant one extension for a period of 1 year. No further site plan application extensions may be granted. If denied, all appeals of such decisions shall be heard by the Planning and Zoning Commission. All appeals must be filed within 10 days of notification of denial, and the appeal procedure shall be as specified in Chapter 902. As is discussed in the staff report, the standard county practice is to review requests for site plan application extensions in a manner that is comparable to the review of requests for extension of site plan approval. And the LDRs state that for requests for extensions of site plan approvals, in the review of such requests, among the things that are to be considered are the impacts of having any new and existing regulations applied to the project. Because the proposed use, which is a concrete plant, is no longer permitted in the light industrial district, it is therefore not possible for the applicant to revise the site plan to conform to the new LDR requirements. And based on this finding, staff followed standard county practices and denied the extension request. As the Planning and Zoning Commission considers the appeal tonight, there are 4 findings that need to be made, and these findings are: 1, did the reviewing official fail to follow the appropriate review procedures? 2, did the reviewing official fail to properly apply the use or size and dimension regulations for the respective zoning districts? 3, did the reviewing official fail to consider adequately the new effects of the proposed development upon surrounding properties, traffic circulation, or public health, safety, and welfare? And 4, did the reviewing official fail to evaluate the application with respect to the comprehensive plan and land development regulations of Indian River County? And staff's recommendation is that the Planning and Zoning Commission, 1, make a finding that the Community Development Director's determination did not fail in regard to any of these 4 appeal review areas, and 2, that the Planning and Zoning Commission deny the appeal and wholly affirm the Community Development Director's determination to deny the request for a 1-year extension of the site plan application.
Okay, Brian, thank you. Would the applicant like to be heard? I assume he does.
Thank you, Mr. Chairman. My name is Jeffrey Smith. I've appeared here before. I'm with the law firm of Smith & Associates from Tallahassee, Florida, and I represent the applicant, Ocean Concrete. We're here tonight simply asking for fairness, honesty, and integrity in the process. We're not here to seek any special favors. We're not here to seek any kind of extraordinary, unusual relief. We're here asking for something that's granted routinely, as a matter of course, to numerous applicants for who are going through the site plan review process. I would submit to you the majority of site plans of significant projects that are over 5 acres in scope routinely are granted a 1-year extension to complete their application process. So what we're here asking the Commission to do is to give us what we're entitled to and a fundamental right that we enjoy in our democratic society, and that's the right to a fair and impartial review. A review that's free from bureaucratic maneuvering, that's free from legal gamesmanship, that is just honest, straightforward, and tells it like it is. If the county staff wishes to deny the Ocean Concrete project because there's been a change in the LDRs, then they need to be straightforward and say, you're denied on the merits because we don't think you can meet the current LDRs. And if you don't like that, you take your appeals and go forward. But instead, what's happened in this process and why we're here tonight is because there's been this maneuvering to try and create the pretext that, oh, we didn't really rule on your project just expired. And that's why we're here, because that's a fallacy. So I'll start with a couple of points. First of all, I have to bring forward in this proceeding an issue about public notice. We have a number of people here in our audience tonight from a group that has deemed itself the Stop Ocean Concrete group. And we just have to state our concern that somehow this organized opposition group was notified of this public hearing tonight before the public hearing was ever publicly announced. And I could submit to you, and will submit to you this evening at the end of my comments, a page from their website that on December 22nd they posted that there would be this meeting before the notice was ever sent out publicly on December 26th. How that happened, I have no idea, but it concerns me as the representative of this applicant that somehow the group, the organized group that is here to try and defeat this project at all costs, gets a personal notice that this meeting is going to take place before we even know about it. And in fact, before our engineer of record who filed the appeal was ever informed. He did not get, Mr. Smith, who will testify later, I believe, did not even receive a public notice of this meeting until January 4th. And that's just wrong. That's just wrong. And it's just indicative of the kind of process that this applicant has been through. I'll set that aside. We're here on the appeal of a simple request for extension of a site plan application. I don't disagree with much of the presentation by Mr. Friedman as to a timeline. Ocean Concrete applied for this site plan approval in December of last year, December of 2006. I'm sorry, December of 2006. I do disagree that raising the 2005 application has any bearing on this proceeding. This proceeding is not about the 2005 application. This proceeding is about the 2006 application and whether or not this applicant is entitled to a one-year extension to have that application heard on the merits. During that one-year period, as Mr. Freeman pointed out, Ocean Concrete not only had to deal with responding to the Technical Review Committee comments, but was put through the task of having to fight a proposed change by that opposition group in the middle of the process and forced to come to the P&Z and to the Policy Advisory Committee and to the Board of County Commissioners. And Commissioners, these things take time. They take time, they take effort. And so if the notion is, well, gee, you should have got it all done earlier, the response to that is we had other things, the applicant had other things that they were required to do in response to actions that were taken to change the rules in the middle of the game. But nevertheless, Ocean Concrete did timely respond to all of the TRC comments, and as Mr. Freeman pointed out, requested an extension of the site plan application. And they submitted that timely under the code section 914.06 4D, as Mr. Freeman pointed out. What that code provision provides is simply that if there's good cause to extend the application, then the application process should go forward and the community development director can grant that request. The only reason, and I want to focus on this, the only reason, if you look at the December 4th denial for denying the requested extension, was the fact that the LDRs, the land development regulations for industrial light zoning, had changed during the process. And that's the only reason offered. There was no other reason other than the LDR has changed, therefore we're denying the extension request. Well, that is tantamount to a ruling on the merits. What they're saying, in essence, is your application can't meet, regardless of how many comments we send you in a discrepancy letter, you're never going to be able to meet it, so we're denying it. But yet, the county was trying to have it both ways. And this is where I'm talking about maneuvering and gamesmanship. Because what the county's trying to do, on the other hand, in the one breath they're saying to us, you can't ever meet the current LDRs, therefore your extension's denied. But in the other breath, the next breath, they're handing us a list of additional discrepancy letter with a list of additional comments saying, well, here's all the other comments you have to respond to before your permit expires or your application expires. So they're trying to have their cake and eat it too. They're trying to say, well, you can't ever be approved, but here's a whole bunch of things that you need to respond to in order for us to review your application. And it just doesn't make sense. So bottom line is, the county sends out a comment letter requesting further information. They send that to us on December 4th. They say, we want further information. Also in that comment letter, and very important, in that comment letter, which is in your packet of materials, so on December 4th, the county concedes they did not complete their review of the application. And I'll read that to you, if you'll just bear with me 1 minute.
Do we have a copy of what you're reading from?
It's yes, you do. It's in your the staff materials, and I'm not sure of your pagination, but it's the December 4th letter from staff to Todd Smith, P.E.
Okay. Thank you.
And if we're all on that page, I would read to you from comment 29, paragraph number 29, where it states, because of discrepancies in site data, stormwater report has not been reviewed. So the stormwater report that was submitted, and Mr. Smith can speak more directly to that, was not reviewed by staff. The next comment says, traffic engineering has not completed its review of the traffic impact study for Ocean Concrete. So there's two comments in this letter. We have not completed our review. There are 33 numbered paragraphs saying we need more information in order to complete our review. Ocean Concrete responded to all of those items by the December 6th date. And if county staff truly believed that there was a need to address these 33 items, then an extension, there's certainly good cause for an extension that's allowed under the county code to extend the request, or to extend the application. I want to address the county's basis for denying the application. Aside from the fact they say, well, your LDRs have changed, therefore we're going to deny you, they point to an inapplicable county code provision that applies not to the request for extension of a site plan application, but rather a county code provision that applies to a request to extend an approved site plan. And they latch on to that because in that provision, which does not apply, it's section 91408 of the county code, that's for approved site plans. And in their December 4th letter, they say, well, we're going to use that provision that applies to approved site plans, and we're going to apply it to a request to extend an application. Those are two different things.
Would you please repeat the LDR number that you say the staff used for approved site plans?
1408.
Section 914.08. And what that provision does is it provides a mechanism for additional time to complete construction once there's been a site plan approval. And if you go down to section 2A, those are the provisions that the county staff was using to evaluate this request on a application. And you're mixing apples and oranges. It's improper. If the county commission had intended this section to apply to application extensions, they would have put it in 914.06 paren 4 on site plan application extensions. There's two different sections. There's one for applications, there's one for site plan approvals. The county commission made the decision when it adopted this code that those criteria applied to approvals. The criteria that applies to extension is simply, is there good cause? Is there a good reason to extend the application process? I would submit to you there is good reason. The reason is the Ocean Concrete was required to respond to a change in LDRs in the middle of the process. And all of the issues were responded to before the permit application expired, and the county staff conceded that they needed additional time to evaluate those responses and had, in fact, additional questions, which they sent in a letter on December 17th and said, here's some more questions that we still have, another discrepancy letter. So we believe and would respectfully submit to you that it was error to deny this extension request. And it is maneuvering, and it's simply an effort to say, well, gee, your permit expired, rather than being straightforward and being honest and saying, we want to deny you because there's been a change in the LDRs. We're big boys. We can take that. If they want to say that we're going to review you on the merits, then give us an honest review and say, that's it. You guys are denied on the merits because you haven't addressed our comments. You haven't adequately responded. Who knows? Maybe we can adequately respond to all of the concerns that were raised. But if it gets down to this one issue of there's a change in LDR, then let's be fair about it. And let's just say that's what the issue is. You're denied for that reason. We'll take our administrative appeal. We'll be back here before you on that administrative appeal, and we'll go to the county commission on it. There's a lawsuit pending on it. I mean, we'll get it resolved that way. But it's maneuvering, it's gamesmanship, and I just implore you that what should happen is an honest and straightforward review of the application. Now, I want to talk a little bit about the four factors and focus your attention, the four factors of findings that you're supposed to make. The first one is, did the reviewing official fail to follow the appropriate review procedures? I would submit to you, for the reason I just explained, they did fail to follow the appropriate procedure. They applied a code provision for approved site plans in evaluating an extension request for an application. So they failed to follow the appropriate review procedure. They followed one for approved site plans instead of the one for site plan applications. The second one, and this will segue into a different area for me, but the second issue, did the reviewing official fail to properly apply the use or size and dimension regulations from the respective zoning districts? And this is kind of critical because I think this is where the county staff is saying, well, we applied the right ones because we're applying the change. Well, that's a critical issue in this whole proceeding, is if they're applying the changed LDRs, then just straightforward say it on the merits. Don't try to make it into this procedural, we were able to put you into a box and say, your permit expired. Just tell us on the merit, yes or no, under the existing code, are we entitled to a permit? If not, if the answer is no, then do we have vested rights? Do we have vested rights and equitable estoppel at work that it would be simply unfair? And that's another key question is, in this whole proceeding, would it be unfair at this point to pull the rug out from under them and apply the new LDRs. And I just want to, this commission has actually addressed this issue of equitable estoppel, and I'll just pause to explain. The legal principle is very simple. If the legal principle and the case law on this is if a developer has expended substantial sums of money, and in this case, the applicant has expended millions of dollars, and time and energy in seeking to get a project approved, is it fair to change the rules in the middle of the game? That's the whole issue of equitable estoppel and vested rights. And that's an issue in this case that's been raised, and it needs to be resolved. It needs to be resolved on the merits. And so when they, if they, in the course of reviewing this application, they say, okay, number one, yes, you've now adequately addressed all our comments, because we're going to extend the permit. Let's assume that's what happened. They extend the permit and they say, you've now adequately addressed all our comments. Now the question is, but even so, should we apply the new regulation or the old regulation? And that's the decision that I think we're entitled to get from county staff, not some kind of game of, oh, gee, your application expired, because we're going to deny you the same right that we routinely grant to others. And I know this is a quasi-judicial proceeding, and I'd simply ask the question to staff, to Mr. Freeman or Mr. Keating, how many extension requests have been granted and how many denied over the past several years? I mean, do we have some notion, and specifically on large projects, how many extension requests are granted versus denied?
Actually, I'd like a more pointed question. How many extensions were granted after the LDRs have changed? Would that be a fair question?
Well, I'd like to know the answer to both, Commissioner Keys. I think that's a fair question to follow mine, but I'd like to know, for major projects, how many are granted?
Actually, I don't have the numbers of how many application extension requests we got and what our determination was, but I can tell you we have denied very, very few, because very few have had LDRs changed that would completely change the review criteria. And I do take issue with many of the things that were said, particularly the issue about changing rules in the middle of the game. When we look at when we look at an extension request, we're looking at actually a new game. We're looking at adding another period to the game, and the criteria we were looking at that time is there are new rules, and if we extend the site plan should be subject to those new rules. That just seems fair, and it seems reasonable. And it actually, a couple of the points that were made, if you look at the criteria that is in the LDRs regarding extension of site plan applications, first, it's discretionary on the part of the community development director. He may extend, and he may extend for good cause. In this case, in making our decision, we didn't want to make an arbitrary decision, so we looked at what's the criteria that's actually in there for extending site plan approvals. And it's rational. Actually, it's common sense that you would use the same criteria in looking at a site plan application extension request as you would with a request for an extension of an approved site plan, which is why we applied the criteria of looking at impacts of changed LDRs in deciding whether or not to grant the extension request. I also want to say we went to great lengths to make sure that the application that was submitted was reviewed under only the rules that were in effect, without any changes when that application was submitted. And we did not apply the changes in the IL zoning district to reviewing that application. We only applied the changes, the impacts of the changes to the zoning district in looking at an extension, in looking at essentially granting another period of review. So I think we acted reasonably, rationally, and correctly.
I appreciate Mr. Keating taking the opportunity to rebut my arguments, but I do have one other question for Mr. Keating, and that would be, setting aside the change in LDRs, would it be correct that if we didn't have that change in LDRs, this extension that Ocean Concrete requested would be granted?
Yes, if there was no change in the LDRs.
And that, to me, commissioners, is the key point. Because what they're saying, what county staff is saying, is we're denying your application on the merits. We're denying it because there's been a change in the LDRs. And they're trying to have it both ways, and I don't think you can do that. The question that we're entitled to have answered, if, as Mr. Keating just said, we're reviewing it strictly under the regs that were in effect prior to the change. If they're going to do that, then they need to do that, and they need to process it just like they would any other application, and then get to that question of, do you have a vested right? Would it be unfair to change the rules at this point? They may say, you know what, it's been so long, it's not unfair anymore. But we're entitled to a fair answer on it. And I just want to, this commission had addressed this issue of fairness previously, and I just want to review a couple of the comments on this issue of fairness, because I think it's critical, because what's gone on here is tantamount to a denial on the merits. Commissioner Smith, and we've set those corridors aside with commercial and with industrial, and hopefully everyone knew that. And then we build things up around those areas, and then we want to change them. And then that's what this is, a change to that, those rules and regs, and I understand that. That part really bothers me. And it's not because Ocean came here tonight so much, because that's basically what we're talking about now. I didn't hear that much talk about the specifics of the change, although staff did a good job of that. But it still ends up being this specific issue. And this individual, the applicant, in good faith, does everything correctly. And I've made this speech before, and invests as an entrepreneur at a high level, and then finds out that those rules are going to be changed. And even though I'm going to vote for staff's recommendation, I definitely feel that this should be grandfathered myself personally. I know it has nothing to do with the vote tonight, but I just can't see the fairness associated with us doing this. Commissioner Lawrence, I'd like to see him grandfathered or some other arrangement made. Commissioner Fletcher, I'm really upset that we're pulling the rug out from a piece of industrial construction that followed all the rules, jumped through all the hoops, and suddenly we changed the rules after he made his application. And that's not fair, darn it. That's just bloody not fair. And that's the crux of the issue. I don't mind a fair ruling. I don't mind a ruling that says, okay, we've evaluated all the facts and circumstances about whether we should review your application through completion under a normal process. As Mr. Keating said, normally you would be granted the extension, you'd be allowed to submit all the information, and we would review it. You either do that and then come to a decision, or you simply say, no, we're denying you on the merits. And let us take an appeal. That's all we're asking. Give us a fair decision, not one that's based on, as I put it, maneuvering or gamesmanship, but one that's fair. So I'm going to close. I'm going to just simply ask the commissioners that you grant our appeal for an extension of the application on the basis that the number one, the staff did not apply the correct rule. And I want to respond to Mr. Keating, who said, well, that's what we do. Well, with all due respect to staff and to the community development director, that's not their decision to make. That's the county commission that adopts ordinance. The county commission decided this is the process that applies to approve site plans. If they wanted it to apply to applications, they would have said, well, this is the process that applies to applications and approved site plans. It's not what they did. It's not what the code says. The code is express and plain on its face, and there's no ambiguity in it. So, with all due respect, they failed the first criteria. They applied the wrong code provision in granting it. So or in denying our extension request. So I would urge you to overturn it, send it back, and tell the staff to simply review the application on the merits, including the change in the LDR and what effect that should have in light of Mr. Mabe's substantial investment, and come to a decision. That's all I'm asking. We're asking for something that's fundamental to all Americans, a fair day, a fair day in court to be heard. That's all we want. And I thank you for your attention. Thank you for your time. I think there's some other people with us this evening that may like to address the commission.
Before you go, can I see if you've had a rather lengthy presentation. There may be some questions with regard to what you said before we move on to someone else. Does any commissioners have a question of Mr. Smith?
I do.
Okay.
Mr. Smith, the statements that were made by the Planning and Zoning Commission regarding wanting to make sure that your client's application was not waylaid because of the land development regulation, when were those statements made? What was the date of that meeting? Do you have that?
I know it was in July, and I believe it was July 16th, but July 20th? I'm sorry. July 20th.
July? So
I remember it was in July.
the land development change did not stop your progression through your application process. You were still really grandfathered in, I mean, basically for that year that your application was still going through the process.
No, I disagree. I don't think that's true, Commissioner Keys. I think that we were waylaid by diversion of time, effort, energy, money, cost to fight a change in the rules in the middle of the game. After all of that, we were then waylaid with an effort to designate a 1.3-mile segment of Old Dixie Highway. Even though the highway runs north to south throughout the entire county, the 1.3 miles that happens to abut my client's property somehow gets designated as potentially a historic roadway. So we're waylaid with time, energy, money, effort to fight that battle on whether or not the road is now going to be designated as a historic roadway so that no further development can occur or improvement to the roadway. So I don't agree, and I think that what happened was we responded to all the comments and staff, rather than simply choosing which way it wanted to go. Either we're going to review it under the existing regs and we're going to treat it like any other application, as Mr. Keating said, but for that change in LDRs, we would have granted the extension. If they wanted to go that path, that's the path we think they should have gone. But instead, they're trying to have it both ways and say, well, it expired, but here we're denying your extension request and we're denying it because the LDRs changed. It's tantamount to a denial of the project on the merits.
With regard to her comments, though, the one thing that does strike me is, because I was at the meeting as well, is that P&Z meeting, when this came up in front of us the first time, the new LDR was not in place. This was prior to that LDR being in place, and I think those comments were with regard to the old rules without the new LDR. So it's kind of like your 2005 application. To me, it's maybe important to you, but it's kind of water over the dam prior absence of new regulation. It's an opinion. We all have our opinions, right?
And I'll leave that to you.
The one thing I would like to
interpret.
Ask you is, and I understand the day in court and fairness probably as well as anybody with what's going on in the past, but the good news, bad news with this is that you are not, as I understand this, there's no guarantee of an extension. I mean, that's part of the dilemma I'm faced with now. Is I understand you got waylaid, and there's nothing guaranteed that you're going to get an extension. Now, maybe Todd, maybe people, engineers, you're waylaid, and it's I won't use the word 4-letter, but it's tough. I mean, so I'm struggling with this time frame because you're right. I mean, you still had. Maybe you could have done this, maybe not. So I understand your argument very well.
Let me just put a finer point on it and respond to that, because I think you're raising an important question, Mr. Chairman, and that is there are no guarantees. There's no guarantees in life of anything.
Correct.
But one thing our legal system and our justice system tries to guarantee, and hopefully our government tries to guarantee, is that people get treated fairly and the same who are similarly situated. But for the fact of this change, we have the testimony in this record that if we were just processing this like any other applicant, you'd get an extension. And I think it's a fundamental due process issue. And I think what's going on is trying to figure out a way.
I suspect we may find that out at some point too. So
yeah, but I appreciate your time and your
If I
attention.
could ask you one more thing,
Okay,
I'm sorry.
I'm here all night long. If
We
you
have,
need me.
and when George explained this, and if we get to the public discussion, we're going to hold very tightly. We have 4 issues. You've addressed them. It is my understanding that the problem with the review is in item 1 with the reviewing failed to review procedure because they used the site plan rather than an application procedure. That's one issue. Then I didn't necessarily understand. In number 2, you said the staff wants to apply the change, and so that's the issue of the vested rights.
Yes, I think that number 2 goes directly to the issue of vested rights and equitable estoppel. Did they apply the correct use and dimension? And I would say no, they
Regulations
didn't.
for the respective zoning districts. So those are you've kind of got the prime one, and the one is number 2. But then, so I'm to understand that 3 and 4 are kind of off the table. You agree with them?
No, and that's fair. And let me not take them off the table because I think Todd Smith will address number 3. It's more of a technical question. Did they fail to consider adequately effects of proposed development upon surrounding properties, traffic circulation, public health, safety, and welfare? That goes more to the direct technical merits of the comments, and I think Mr. Smith would tell you that no, we don't agree with the direct technical comment.
That's why I'm asking. So.
And then, did they fail to evaluate with respect to the comp plan and land development regulations? And again, if you read the response of staff, they said that this is again the denial of the 1-year extension request of the site plan was specifically based on the fact that the proposed project could no longer comply with the existing LDRs. And I would simply submit that under this criteria, the reviewing official did fail in the duty to evaluate on the merits instead of kind of, I guess what I would call a de facto ruling on the merits via the vehicle of denying an extension request. So I would say yes, that criteria is also not met.
Okay, thank you.
Thank you.
You had, excuse me, correct.
I think I'll go ahead now. I was going to wait, but I want to ask Bob, and I think it's appropriate at this time. Bob, when you made comments based on the application, all through this process you've been using the criteria before the LDR change, before the zoning change. So you're saying, I don't want to put words in your mouth, but I believe you're saying that were to you use the new regulations, or the regulations would apply to the new zoning, that would be denial. You would deny that at that time because of the new regulation, and that's why you use the site plan approval segment, because they would not make it under this new zoning criteria with the same type of application.
That's correct. All of our reviews, substantive reviews of the site plan application, were based on the land development regulations that were in effect before the change to the IL district regulations. When the issue of an extension came up, the request for an extension came up, I looked at the criteria that I have to follow in doing that. As I said before, it's a discretionary criterion. The community development director may grant for good cause an extension of up to 1 year. So there aren't specific criteria other than for good cause. Now, what we wanted to do was to show that we weren't being arbitrary and capricious, so we cited a comparable LDR section, the criteria for the extension of approved site plans, And it's only common sense, and it just makes perfect logic that you wouldn't extend an application if under the same circumstances that you wouldn't extend a plan. So I think what it does is there's no mandate that we follow a set of criteria and not other criteria making this decision. This is discretionary. It's a may. And that allows us to consider other criteria. And I think the justification we have in here shows that it's not an arbitrary decision. It's based on reasoned thought and common sense.
Thank you. You had any other questions? You said you wanted.
I have nothing.
You have nothing else, but you said you wanted Todd, or you have.
Yeah, I'd like Todd Smith to come forward because I think he can address some of the issues maybe that as a lawyer I'm not directly hitting on the nail on the head. So I'll let Todd come forward and do that.
Todd Smith, engineer for Ocean Concrete. Just to kind of clarify a few of the points and a few of the statements that were made, because it was brought up in Mr. Freeman's original presentation about our first 2005 application. There seems to be this error that we had this first application, we had a year with that, and then we made another application December 2006, and we let a whole nother year go by like we've been just sitting around doing nothing, trying to move this project forward. The 2005 application was purposely let to expire because knowing that the site plan extension process is a one-time only approval. And there was concerns on our part whether we could even satisfy all the reviewing agencies, 5 different agencies, DOT, DEP, St. John's, County, and the FEC, 15 different permits in a 2-year period. And when I hear the phrase about good calls...
You let it expire and then just so you had room for another extension if you could get...
Correct, because we spent the first year basically securing St. John's and FEC approval. So, I mean, we spent 12 months just jumping through the hoops of 2 agencies. And knowing that the St. John's approval was 5 years, it didn't affect us by basically playing out that strategy, and there was no time limit on the FEC's approvals. So that was a decision that we made. And then as far as the 2006 application, as my colleague said, we spent a considerable part of the year defending the Historic Resource Committee's proposal on preventing any alterations to the road, which basically would kill any development on this property, and as well as addressing the ordinance change of restricting concrete plants from IL zoning, which came before this board and then eventually before the county commission. So I want it to be clear and on the record that, you know, the staff of Ocean Concrete, we may not be a 10-member engineering firm, but we've been moving forward as diligently as we can to jump through all the hoops. Going back to comments from Commissioner Keys, when the Planning and Zoning Board made their motion to the county commission regarding the change of restricting the concrete plants from IL zoning, that went to the commission. When the commission approved that ordinance, it was effective, I'd like to say immediately or within a legal recording time. There was no acknowledgement of Ocean Concrete's grandfathering, Ocean Concrete's estoppel rights, Ocean Concrete's vested rights. So right then, the axe was dropped, because regardless of any extension, regardless of any comment letters, there is no way that we could have secured an approval on this site plan within the 12-month period. Impossible. No way at all, because even though Mr. Keating wants to take the position that, well, we only reviewed it based on the old ordinances, if we had come and said, okay, we have dotted every I, every comment has been addressed, and that is our position, because we do feel that the comment letter that was finally issued on December 4th and the December 17th letter, you can see the progression. December 4th had some landscape comments which were all resolved, acknowledged by staff to the December 17th letter. The only remaining comments in December 17th from traffic engineering, which we did meet with the traffic engineer and had potential solutions for that comment, and we still stand that our traffic study is correct, but we have not had the opportunity to have the meeting of the minds of engineers to hash out whose methodology is correct. And that remaining comment letter of December 17th is exactly that. Some of those comments are inaccurate. We've tried to set up a meeting with Public Works Department. We were informed they refused to meet with us unless it was scheduled through the county attorney's office. We were informed that the county attorney's office couldn't accommodate the schedule prior to this meeting because we were hoping to resolve whether those December 17th comments were even correct. And the point of all of that is, if all those comments were 100% correct, you still wouldn't have gotten approval, because whether they want to say they've only reviewed it under the old ordinance, the new ordinance is in effect, and it was in effect back in August when it was approved by the county commission, which is why we requested the extension. So I do realize that the granting of the extension, as Mr. Keating says, is discretionary. It's May. But, I do think, again, going to fairness and good reason, in our country, we do have a judicial system, and there has been a controversial ordinance that has challenged what the county has done regarding the IL zoning. We've bitten the bullet on it. We have filed in the courts, and all we're asking for is, and even Mr. Keating stated here tonight, that if it wasn't for that ordinance change, the extension would have been granted. So what we're saying is that approve the extension, give us the right to appear before a judge, challenge the validity of the ordinance, which is denying our extension right here. It's not like a maybe. The suit has been filed, and give us the opportunity for our day in court. And if a judge doesn't overturn that ordinance, then this whole argument is moot anyway, because the project will be denied. Because as right now, the staff could have sent us a letter saying the project's denied. Staff could have issued an approval of the extension, sent us the December 17th comment letter, and said project's denied. We granted your extension, but you can't meet the new ordinance, which is in effect. So that's why we feel that there's been some erring along the way on staff's part. As far as the additional reasons, as far as number 3, I think that kind of ties back into the December 4th letter, which 3 different staff members, planning department, acknowledged in comment number 9 that they did not complete a review of a sound study that we presented, and traffic engineering in comment number 30 acknowledged that they did not complete its review of the traffic study, and in comment number 29, Public Works acknowledged that they had not reviewed the stormwater report, which I find remarkable because some of the comments in here are regarding stormwater, yet he acknowledges that they didn't review it. So I think that ties into reason number 3 on how can you properly consider surrounding properties and the more technical aspects of the LDR when you have 3 different departments making their own acknowledgement that they didn't complete their review. And I think that kind of dominoes into reason number 4, because the comp plan, one of the main goals of the comp plan drives the creation of the LDRs. So if you violated by not following the LDRs, I think that kind of tags along with you didn't meet the goals of the comp plan. I think the two of them kind of go hand in hand. So that's kind of how I would address reasons number 3 and 4. Just bear with me 1 second. And that's about all I can add. Just I'd like the board to keep focused on that there was no way that we could get an approval because the new ordinance is in effect.
Todd, wouldn't that though lend a little weight to what he's saying about the extension? If you couldn't get the approval, all he's saying is you can't extend because you don't meet the criteria. Is that right?
But the issue to us is that we have challenged that in the courts. So, it's our position that we intend to get through the courts within the next 12 months. And, what does it hurt giving us the extension? I mean, if this new ordinance was not passed, then this project would have proceeded forward like any other project in this county. There's no other aspect associated with this project which says it can't meet compliance with the codes, can't be built. It's strictly the IL zoning issue. And again, all we're asking is just let us get before the judge. I mean, and that's why I think my colleague is making references to legal maneuvering, because it seems like what's going on here is it's a prevention of letting us get to court to challenge that final BCC ruling on that IL zoning.
Before you take, anybody have any questions of him? I have one quick one. In this, because you're specifically, we're talking about the 3 and the 4, more specifically number 3, without the court case, because Jeff had already covered the others. On your traffic, the discrepancies on the traffic, like traffic reports or the stormwater reporting where they had not completed their part of the studies. Bob, in here, in that letter on December 4th, it says we did not complete the review, and most of the time it has to do because of discrepancies. What would be a standard procedure? I mean, if you all, when these review letters go out, if there are discrepancies, is it the burden of the applicant, or you all you've listed discrepancies? I mean, how timely? What's the timeliness in the response back and forth? That's why I wanted you to wait, Todd.
As you indicated, some of the items in there where it indicates something was reviewed, like the stormwater. The stormwater wasn't reviewed because there was discrepancy in some of the data, which makes sense. If you see that there's a different impervious surface number in a text, in a report from a site plan, you need to figure out which one it is. And it doesn't make sense to review the report if you know that the number might be wrong. And I think that's what you see referred to in a couple of places, that something wasn't reviewed because of something else, and particularly with the stormwater. And these are the types of discrepancies we sometimes see. That, like I said, we sometimes see an engineer submit an actual plan that is the drawing, and it shows impervious surfaces, and the plan will actually list impervious surfaces on there. The report may list a different number, and we don't know which one's right and which one's wrong. And in that case, you don't want to go through and look at all of the stormwater data if that's the number that's wrong.
If I may add just a couple comments to that, I think that logic could not apply to the traffic comments and the sound report not being reviewed at all. As far as the stormwater goes, I understand Mr. Keating's position on it. On the other side of the coin, a lot of comments that come out of stormwater, because it's not an exact science, is no more just a difference in methodologies between engineers. I may use method AA, the county uses method AB. Doesn't mean I'm wrong. It doesn't necessarily mean they're wrong. It just means it takes time for two engineers to sit down and say, well, this is the way I was taught to do it, and another engineer, yeah, oh, I see that makes sense, and then he shows me, well, this is the way we do it here. Oh, okay. So it's not really an issue of right or wrong. It's more of an issue. And again, this ties into the extension request, because when you start talking about area calculations, it's very easy for a staff member to pick up a phone and do it every day and say, you know, we just started this review and we got this one number here. On the plan it says such and such, but on the report it says such and such. I've been trying to get a meeting over the impervious areas, which to me are nothing more than third grade mathematics, and to show why they are 100% correct. But I have not been entitled to be able to prove that, because nobody wanted it presented before this board tonight. And that's why we want the extension. Who's right, who's wrong, and is maybe everybody's right as far as stormwater goes.
Okay. Thank you, Todd.
I've got a question for you. Do you not agree that as engineer to engineer, private engineer, county engineer, that if the county engineer says it's AB, you're going to have to show that you're AA meets their AB criteria. The county's not going to say your AA is okay with us when they've got an AB requirement.
I think a lot, let me put it to you this way. I feel 100% confident in the stormwater report presented based
What I'm asking you, Todd.
What's that?
That's not what I'm asking you. I'm asking you if the county regulations are going to have to be followed, no matter that you come by a value in a different methodology. You've got to get the county to agree that your methodology meets that AB criteria.
Oh, absolutely. I mean, the county codes have to be followed, but I mean, my methodology may be approved by the LDRs. I mean, you know, you get into modeling and I mean, to give you an example, the whole thing over impervious area, the reason the two numbers don't add up is because Public Works, there was a gravel service road that was semi-impervious area. If you take that impervious area and add it to the impervious area, it matches the report. Two numbers, addition. If I had the opportunity sitting down with the reviewer, it's on the plan. And in the stormwater report, it says even though we're proposing the gravel road as semi-impervious, we're going to treat it as impervious in the stormwater report to allow for a future paving of it. So this is how confusion starts, because he, on looking at it, says, oh, these two numbers don't match. But it's just a simple explanation. They are accurate. It's just give me the 5 seconds to clarify it to you of why they don't match.
Okay. Todd, any other questions of Todd? Mike?
Thank you.
Mr. Chairman, I had said I would present earlier a copy from the Stop Ocean Concrete website.
I assume that if you're done, then we'll...
I think Mr. Mabe would like to address the commission.
John?
Go ahead and jump, John.
Up here, you, John.
Good evening, Commissioners. George Mabe, 11085 Old Dixie Highway. It's been since early this year since we've discussed my situation. First off, let me say, with regards to staff's position here, I think that that's been a very difficult decision here. I understand their interpretation of it with regards to the new zoning change. And I think basically you've heard my technical aspect here. You heard our legal aspect of it. For me, simply, again, to reiterate that the decision is inevitably going to be decided by a judge in a court of law. And I would simply ask you to allow me the opportunity to see our last couple of years' work come to fruition for good or for bad. I know we're right. I firmly believe that the thing will stand on its own 2 feet with regards to staff's review. Again, inevitably in the next year, whether it's approved and it's correct or not, the decision will, if the thing goes forward in the courts, then I'll be back here operating my batch plant. If it isn't, I will find another use to implement on the property. And much of the work that we're discussing here, the future road improvements, the site itself, all will be utilized in another acceptable design, which we will present in front of staff here shortly. But with all of that said, I don't think there's much more that I can say, and that I hope that you will just give us the opportunity to see the work done and explain completely. I know what Todd has done here. The time frame and everything, the man's extremely complete and thorough, and I have all the confidence in the world in his calculations. And again, we've tried on several points to try to discuss this with staff and bring it to light so that it's very easily explained. We've never had the opportunity. So with all that said, we would like that opportunity, and I have nothing more to say. Thank you very much.
Jeff, does that complete your presentation? I assume you want to hold, if we have a public discussion, do you want rebuttal at the end?
I would appreciate the opportunity to just address any points that might be raised. Thank you, Mr. Chairman and Commissioner.
Mr. Chairman,
I'm sorry, George.
at some point I'd like to go ahead and have a discussion with the board about some of the legal arguments raised. That's at your pleasure, whether it's before or after.
I'm going to get to that. Before he sat down, he
Absolutely
make sure
right
he knows and everyone knows that he does have that right. Next, we'll have a discussion among ourselves briefly with staff and with our attorney, and then we'll open up a little bit of discussion, maybe. Go ahead, George.
We've heard some assertions that this is a legal maneuvering that's caused this, and that's actually the furthest from the truth. The arguments tonight are being mixed. This is not an argument on the merits of their site plan. This is an argument on the extension, the denial of the extension. In looking at some of the factors, we have been told that staff cited the wrong section when they looked at whether the extension should be granted. The section says that the community development director may grant upon a good cause, of showing of good cause. Now, staff looked to the LDRs to try to determine what should satisfy that requirement, and that's not being arbitrary, it's not being capricious, it's using the code to define the standards, which is discretionary. Now, we've heard this talk about vested rights and equitable stop, and it is actually correct. And here's actually the position that the county attorney's office took from the day that the LDRs got amended. The rule in Florida is that it is the law at the time of approval which governs an application. It is not the law at the time the application is submitted. That is the default. So when the LDRs changed, the default rule was that the ocean concrete application was not allowed. However, there is an exception. If you can prove that you have vested rights in the old regulations, in the old laws, then you can follow and you can proceed under the old regulations and not the new regulations. There are two ways for showing this. The first is through equitable estoppel. The second is by showing that the government acted in bad faith and somehow delaying the project. Knowing that those were the two standards, we were not going to delay or do any unnecessary action which would be construed as causing their project to get held up. That is why we inform staff that they should continue to evaluate the project on its merits, because it's a two-step process. First, you look to see if they have vested rights in the old regulations, and then second, you see if they can satisfy the old regulations themselves. Rather than get into a long, drawn-out battle of whether they have vested rights or not, we said, let's just see if they can satisfy the old rules. If they can't satisfy the old rules, it is not necessary to get into a conversation about whether they have vested rights, because even if they have vested rights, if they can't satisfy the old regulations, it doesn't matter. So that is why staff has evaluated the applicant's project based on the old set of regulations, because if they can't meet that, then we don't need to get into discussion of whether they have vested rights. So that has been the philosophy from day one. Now, what we are here today on is the denial of the site plan, of the application for a site plan extension. That application occurred after the LDRs had been amended. They cannot vest a right in that application because the application occurred after the LDRs had already been changed. It's not like the application on the site plan itself, which came about previous to the LDRs being amended.
Time of approval, yeah.
The application for site plan extension occurred after. So again, the default rule is you govern it based on the regulation that exists at the time of approval or denial, unless they have vested rights in a previous regulation. But there was no previous regulation prior to their subsequent to their application. It's been a universal rule that that is no longer permitted. Now, we also heard some references to this committee's responses to when the LDRs getting amended the first time around, and several members of this committee expressed a desire to have some type of grandfathering, some type of regulations that vest the rights in applicants. People who are going through the process should not have to fall under the new rules, and that was very reasonable when it was sent out to the Board of County Commissioners, and the Board of County Commissioners rejected that notion, which is their perspective. It is a different standard what we are looking at now. I understand what many of the feelings were for that previous vote, but this vote is simply looking at staff's denial of the extension. It is not looking at whether it was fair or not to grandfather applications when they amended the original LDRs. Further, we've heard some comments that staff sort of just stopped talking to the applicant, and the applicant has been unable to, clarify some of these comments. Well, the problem with that is that the applicant chose within their legal rights to sue the county. I believe that the lawsuit was premature. It was filed previous to any denial whatsoever. But when you file a lawsuit, you sort of tie your hands to be able to go in and talk regularly with the person you're suing about the item that's what's being brought before the court. I mean, that is why there's been little dialogue. Now, we made it perfectly clear that staff should continue up until the time that their application expired, that they should continue to evaluate and provide the comments and do everything they normally would as if the regulations had not been amended. Because, again, our philosophy was if they can't meet the old regulation, we don't have to get into a battle about whether they have vested rights to be exempt from the new regulations. And so I think staff has done that. We worked closely with staff, and they did. They provided feedback. They even reviewed the application after the application had expired. So they got the response letter to staff's concerns. They got the response letter. They evaluated it after the application had expired because technically what we told them is if their response actually satisfies all the comments and it's good to go, they crossed their T's and they dotted their I's, then we would have to get into a conversation of vested rights. And we were okay with that. We're not here to try to somehow shortchange Ocean Concrete. What we were told is they did not satisfy the requirements of the code as they existed prior to the change, and the application had expired. And so because of that, the new regulations are in full force and effect. And so I believe staff has correctly analyzed the application for both. And again, we're limited here to the extension of the site plan request, not the actual site plan itself.
Okay, thank you. Any questions of either staff or our legal counsel?
Yeah, I have, don't know how really to articulate this. I want to try to make it as simple as I can. If an applicant has a piece of property that they want to put a house on, and they respond to the requirements to put a house on that property, and then the requirements change and there are no houses allowed, during the process when they are applying and responding to the county, the rules change and there now can be no house on that property. Okay. It seems to me that the only issue, and in this case, was that change in the rules and regulations to deny having a house on that property allowable and proper. So it seems to me that an extension for any purpose is just going to delay and take more time in the process, in that the final decision is going to be, can you have a house on that property or not, and what do the courts say? So I really, to tell the truth, I don't really understand why an extension should be given to let someone respond to when the house could have gone on the property, when now it can't. I just don't understand the need for an extension to try to respond to the time when it could have been put on there. Confusing, but that's what I think.
Anybody else want to take a shot at that? Anybody else? Okay, this is a public discussion. We're dealing with a situation, as you know, we've got 4 criteria. The staff's position is clearly that this does not qualify. Is there anyone out there who would argue that in favor of what the applicant in favor of the appeal?
We have a taker.
Yes, sir. Come to the podium, please. If you're in favor of the appeal, because the assumption is if you're not in favor of the appeal, you support the staff's case.
Hi, Commissioners, Mr. Chairman. Thank you for your service. My name is Charlie Wilson. I live at 1935 19th Avenue. You might have seen my new movie. In full disclosure, I want you to know that I work with Ocean Concrete on another matter, on the matter of the historic situation on the Old Dixie Highway, but I do not represent Ocean Concrete in this particular matter or in this action, but I am familiar with the process. My concern is this going to be the policy of this county, where someone can be delayed long enough that it then becomes a single person's decision whether a project can go forward or not, as wonderful of people as they may be. Yes, it says that he may approve this, but it also says that you may agree. So,
or may not.
There's a similar situation that Mr. Chairman may be familiar with. I like working in Indian River County a lot better than I like working in St. Lucie County because they have a controversy down there, but in this case it has to do with agricultural land. And essentially what they did was they changed the rules in the middle of the how to figure property and agricultural land and made a significant economic impact on people in the agriculture business.
Incorrectly, I might add.
I'm certain of it, and I think that this is done incorrectly just as well. In fairness, this is a technical place, and we're supposed to follow the rules when we're here. We can leave some of the politics to the county commission, who occasionally may consider political consideration. I would like to read just a section here from Sebastian Concerned Citizens, which is the Stop Ocean Concrete site, because it throws a little light on this process. They have 5 or 6 things that they say that they want to accomplish on this website. One of it says, find legal and technical issues that will stop the county from issuing any permits. Another is work to have the zoning and land use plans changed to prevent this from being an ongoing problem. Another is create political pressure on elected and salaried officials to find ways to turn this project down. The next one is to make certain that Ocean Concrete knows that they will have to obtain every possible permit to build this plant and hope they will not be willing to do this and quit. And I submit to you that that's what's happening here. I don't blame these nice people and all these nice people from Sebastian who are worried about their property and worried about their rights.
Remember 4 points, Charles. We got 4 criteria you got to deal with. If you're in favor of us supporting an appeal,
I don't believe that they have followed the number 4. Okay. And that is because these nice people, we haven't even gotten to the place yet where we're able to address these nice people's concern. Because what would happen if if we could guarantee no pollution, no transportation, no noise, no light, and no problem? Then there wouldn't be any objection to this particular thing because you're hiring 50 families. We just haven't been allowed to even address the concerns that Mr. Baker may have about pollution. But it's not because we haven't tried. And so I believe that you should grant this extension so that we can at least, we'll meet with the people and we'll try to get their objections overcome.
Okay.
Thank you very much.
Thank you. Anybody else in favor of the appeal? There was, under the public discussion, the assumption I have there is that most of you all then are against allowing the appeal to go through. We've got other items on the agenda. If there's someone that's just got a biting urge to speak, we stick to the 4 issues, and then more importantly, you're invited to do. If you have to be sworn in, I know we had 1, 2, 3, 4 people sworn. Please come up. Remember, we're dealing with it's not the merits of this, and it's.
I wish to correct the subsumption that Sebastian Concerned Citizens.
I need a name and address, please.
Kelly Mather.
Okay.
Mr. Smith said that concerned citizens from Sebastian website got advanced information on when the site. He underestimated us. In December, we looked ahead and said, when will you meet? And we said, that's basically when you're going to hold this meeting. We put that information out early to our constituents so that they would know. If it was wrong, we would have changed it.
Okay.
And we have the ability to do that. So it is not what they said, and I wish to correct the record.
Yes, sir. Okay. Who else were you sworn in, sir? Okay. Your name and address, please.
William Cox, River Run Drive of the county. From what Mr. Smith even said, that he allowed the initial permit to expire so that he could file a second permit and get an extension on it. Constructively, he receives his extension on the second permit.
No.
However, on the first permit, he didn't even respond to comments.
We're dealing with the second permit's extension, which he is perfectly in his rights to ask for. So
I do not believe he should receive that extension because he has not met the requirement as of the time that the permit expired.
Okay. Thank you very much. I think there was back in this corner, we had a couple of gentlemen that were sworn in. Would you all have any other comments? Okay, the public discussion is closed. I'm sorry, this public discussion is closed. I gave Jeff the statement.
And I will be brief. I just wanted to respond to a couple things. One, a little jousting with my esteemed colleague, Mr. Glenn, on the issues of vested rights and equitable estoppel and where we are in this proceeding. Mr. Glenn posited that the position was if they can't meet the old regulations, then we don't have to deal with that sticky issue of vested rights and equitable estoppel. I'd just like the record to be 100% or 150% clear that it is Ocean Concrete's position that it has indeed met all of the old regulations. There's simply a need for time for staff to evaluate that and to come to a reasoned and objective and honest and fair and straightforward decision on that question. And that's what we're asking, that the extension be granted so we can answer Mr. Glenn's question, can they meet the old regulations? Because honest to God, there's no reason we can't meet the old regulations. And so it really does come down to the issue of equitable estoppel and vested rights. I don't disagree with Mr. Glenn substantially on the law. I do think he's overlooked a couple of cases. I won't bore you with the details, but I will tell you I agree generally that bad faith is one of the standards to establish that you may travel under the old regulations, and I think one element of bad faith is if you are deliberately denying an applicant the opportunity to show that they can meet the prior regulations, or if you're moving the goalposts during the game. The issue of vested rights and equitable estoppel, I think, is going to be one that, of course, the courts are going to look at. But I think in honesty and fairness, it's one that the county should look at before we get there. I mean, we're going to exhaust our remedies here. We've raised the issue. We've put it in, unfortunately, in your laps tonight. But we'll be back here very soon on the denial letter, which followed the denial of the extension. There's a subsequent denial letter which has been appealed to you, and we had hoped we could consolidate that so we could do it all tonight, but that wasn't possible. So we'll be back in a couple weeks, depending on your vote this evening, to argue that. But I just wanted to make our position clear that in response to Mr. Glenn's question, we absolutely 100% positively can demonstrate compliance with and believe we have demonstrated compliance with the old LDR regulations. And so that does bring us to that sticky issue that I think, in all fairness and honesty, and I'm not, I don't like to take shots at people, but I do think it's a maneuver to try and say, well, I don't want to address that sticky question of vested rights, so I'm going to run out the clock on you. So that's all I have to say. I don't think I want to respond to anything else. I appreciate your time and attention tonight. I just, in closing, urge you to grant the appeal and the extension request. Thank you.
Thank you, Jeff. You're always welcome.
There was a guy in the
Jeff.
back there that wants to.
The reason, sir, were you sworn?
I wasn't sworn, but I did want to have something to say.
I appreciate that, and I'm sorry that I must have overlooked you when I closed the discussion, and the public discussion is closed. I'm sorry. Any other comments?
He came in late. He came in after the swearing in.
Oh, he did? Okay. All right. Come ahead. We'll open the public discussion. Please swear him in.
Yes, if he's for or against.
Yeah. I didn't see him come in. You understand that we're addressing the 4 criteria, not the merits of this case. You understood
Yes,
from
I
the
understand it, sir.
Okay, very good.
Would you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay.
My name is Al Manzi. I live at 742 Holden Avenue, Sebastian, Florida. Commissioners, staff, and ladies and gentlemen, I believe that everybody here is trying to have fairness, honesty, sincerity, fair play, and impersonal input in this. I really think everybody is trying to be as honest as they can. I don't believe this extension should be granted. As I've followed the conversation, and I might have this wrong, Ocean Concrete did not respond because they were too busy, quote unquote, responding to other agencies. And that later on, they reapplied. Now, if they felt that their original plan should go ahead, why did they reapply? When they reapplied, the new regs were in place. If anything, these gentlemen are no babes in the woods. I would like to know, in their research, have they ever found a community that's embraced a heavy industry moving in? Or not? Fight it. There's only one place I can think of.
Remember, 4 All
right.
Let's keep it tight,
Bhopal,
please.
India is the only place I can think that didn't fight a heavy industry coming in. Have they ever had where a heavy industry was included in a light industrial zone? Concrete plant included in a light industrial zone?
That is not for consideration tonight, sir. I'm sorry.
I just have a feeling that we're asking the staff to roll over for vested interest of a party that really did not expect to have to go
The
ahead.
staff hadn't rolled over. The
Thank
staff
you,
is
Joe.
saying no right now. Pretty firmly. Okay, thank you. Have I missed anybody else? I'm not trying to overlook people, but the assumption is that if you weren't speaking in favor of this, the staff's position is fairly firmly against. So I don't know they need a whole lot of support, but I don't want to cut anybody off before I close this again. Okay. Going? All right. We're closed.
I'd like to make a motion,
Mr.
if
Chairman,
I
I'm
may.
sorry, real quickly, since you did open up the hearing again, if Mr. Smith would like to respond to any of those comments, I feel it'd be fair if he has an opportunity.
That's fair. I'm afraid so. You rebuttal again? Okay. All right. Good point, George.
Okay, I'd like to make a motion that Planning and Zoning find that staff did not fail in regard to any of the 4 appeal review areas and that we uphold their denial of the extension.
Okay, right. Do I have a second? Second. We have a motion and a second. Any discussion? All those in favor say aye.
Aye.
Aye. Opposed? It's unanimous. Come again, Jeff.
See you.
All right, thank you all. If you're not going to stay for the rest of our meeting, we'd ask you to try and leave quickly and quietly. We appreciate your attendance, but we need to move on. Thank you. We'll take a 1-minute break.
Why? Oh.
Blood flowing on his feet again.
1 minute's not 1 minute. Item number 6. This is unlike the last one, this is a full public hearing rather than a public discussion. It's Indian River Estates Phase 3, a request for major site plan and special exception approval to construct total care facility. Stan? Oh, Stan's not here. Stephen, I'm sorry. We're not doing too well on names on anybody tonight, are we?
Oh, Leroy.
Yeah, Leroy.
Turn your mic on, Steve.
Thank you. This is the Indian River Estates Phase 3. This is a special exception use. The location of this site is between 74th Avenue and 82nd Avenue, 26th Street to the north, and State Route 60 to the south. The area, grade area on the map that you're looking at is the overall 3 phases, with the 3rd phase.
Back away, please.
Back up a little. It's these work about 10 inches or 12 inches back better. It's the new technology.
The Phase 3 is outlined in red. The proposed site plan is somewhat extensive. This was a former grove, 10 acres in size. The 120-bed skilled nursing facility outlined in blue here is proposed. Now, 100 of these beds come from another facility on site, and those 100 beds will be closed down and will be moved to this location. The site plan also has a 40-bed extension, and that 40 beds was calculated in the overall density as if they were there. There are 22 villas located within 11 buildings outlined in light blue, and there is an internal pedestrian and sidewalk system that links all of the benefits, the stormwater track, all of the housing and buildings together. Off-site improvements for this project include paving 26th Street from 74th Avenue west to about 50 feet west of the entry. In addition, the applicant and the county are working on paving at 22nd Street all the way to 82nd Avenue. The proposed landscape plan provides for a 50-foot urban service area buffer along 26th Street abutting the 2 villas there on the north side. There's a 25-foot Type B buffer abutting the RS6 zoning to the west and south of the site. There's a 15-foot roadway buffer abutting 26th Street. There's an irregular shaped stormwater track per code. In addition, the littoral zone has been added at the south end of the stormwater track. Although this was a former grove, there are 13 cabbage palms on site that will be relocated into the landscape plan. And this is an artist's conception looking from the west towards the east. So what you're seeing there is the future expansion of this project. At this point, staff recommends that the Planning and Zoning Commission recommend that the Board of County Commissioners grant special exception use approval for the proposed total care facility with the conditions listed in the staff report. Thank you.
Thank you, Stan. Any questions of staff?
Yes, I have one. Has the fire department approved this plan? It seems to be kind of crowded in there for fire services. Do they have to approve something like this?
I'm sorry, fire services?
Fire department, yeah.
Yes, they have approved the site plan.
They have approved the site plan? It wasn't in our backup, right?
Let me just tell you, fire department coordinates with us and looks at the site plan, which is the external part. They will also look at the individual building permits for the internal structural vertical construction fire NFPA criteria.
Thank you.
Would the applicant care to be heard? Come on up.
Good evening, Chairman, Commissioners. My name is George Simons. I'm the project manager for Carter Associates, 1708 21st Street. I'm going to try to keep my comments very brief, but first I would like to thank staff for their review and their recommendations. If you have any questions, I'm here to answer questions, and also we've got the project team here. We've got the owner's representatives, the architect, the traffic engineer, and the landscape architect, so I think we've got everything covered if you have any questions. One thing I'd like to clarify, just so there's no confusion, is on the density. We didn't include the 40-bed expansion in the density calculation or in the traffic study. We've got the 20 beds, which would be the additional 20 beds that's going to be in the new building, what's called the skilled nursing building. 100 of those beds currently are on the existing site. That operation will be transferred to the new building, and there'll be an expansion of 20 beds. And on the floor where the existing 100 beds are, we're saying that will be revised to a new 20-bed. So they're taking the 100 beds that are there now as a skilled nursing facility, and they're going to make the rooms bigger, end up with only 20 beds there. So we've got a 20-bed increase in the skilled nursing facility and a 20-bed increase when the renovation in the existing building happens, and then we've got the 22 villas. So that's where the traffic study was based. Also, I'd like to just point out an observation that is worth bringing up, that the facility is existing. It's a great asset to the county. We've got a long track record of being a good employer and a good neighbor during the storms. They had people standing out there with the generators and having meals and stuff when they weren't able to stay in their own homes. So it's kind of company we want to encourage to continue staying here and expanding, and they provide important services for the people here. So we would request that you recommend to the Board of County Commission approval.
Okay, thank you. Any questions of the applicant?
No, I have a staff.
Okay. Questions, staff or applicant? Go ahead.
Bob, there's no additional requirements under traffic circulation. You're telling me that the entrance from 26th Street for a guard station or whatever guard entrance area is the only additional access that would be applied? You're adding all these beds, and you're telling me there's not going to be any additional traffic requirements. They're going to be all captured internally?
Actually, Brian, I don't know if you want to address this. I think there's no additional access point for the project except this new one on 26th Street, but there is access to the rest of the project from this new phase.
I apologize, I was dozing off back there. Could you ask? It's been a long...
My concern is that all these extra beds are going to increase traffic flow or capture some traffic from off of the street, and with only one extra road being added, and that just being a guard access road, I'm concerned about the access from the public.
On 26?
Well, 26 and your other, that's not true.
26. No, there's that.
All this traffic internally?
There's
Can't believe it.
2 driveway vehicle access connections that were analyzed, 1 to 26, and then the existing main connection. There's also an existing third one that lies to the east of the property, just due to the proximity. I don't know if the
That's right.
site plan.
Is that this one here?
Back in the top corner there.
Yeah, right here. You've got your main. This is the new, and there's another entrance right here.
Well,
Look.
there's one very far over to the very east
George?
of the property.
Oh.
That's
Back in
existing,
here.
but
Oh, okay, okay.
due to the
Oh, yeah, that's
proximity,
right.
it
Off
just
the
didn't-
right.
It's,
I
it's not realistic to use.
74.
The driveway connection on 26, yeah, there's only, during the PM, there's only a projected increase in traffic volumes of about 23 net new trips for the project.
The whole project?
For the whole project.
With the people in the villas?
The net new, yeah, which includes the
overall increase.
The 20-bed skilled nursing, the 20-bed assisted living, and the 22 multifamily units. When you look at the trips associated with those 3 uses and those development intensities, we're only looking about 23 new trips in the PM peak hour. And when you divide them over the 2 driveway connections that we have, we only have a handful of trips that we're looking at.
And you've added a third in the new project, right?
The 26,
Right. Yeah.
yes.
Yeah.
Okay. I just have a problem with it, but I've been associated with the elderly for a long time. I'm deeply appreciative of what you're going to do here. This is a wonderful project. I'm just voicing my concern that I want to make sure it works. I'll be supporting
real
this.
sensitive about that. Okay. Any other questions?
I have a question on a landscape plan. Is there someone to answer that? Landscape?
Is there a green person here?
Is there a reason you're not relocating that 14-inch oak tree? What kind of condition is that oak tree in, that you're not going to relocate it?
We are actually looking at that.
And?
So we have been looking at that issue to make sure to see if it's possible to relocate it, but it is a nice tree and we're trying to do our best there.
Okay. And the other question was, the other oak trees on the property, they must be very small, or,
They're all under the 14-inch.
but are they of any kind of quality? I mean, you're moving palm trees, but you're not moving any oak trees.
The palm trees are a lot easier to relocate.
Well, I would understand that, but
we all know that.
The oak tree's a little more valuable.
There are also laurel oaks, not live oaks, so
Okay.
they don't transplant as well. So that was another issue that we were dealing with.
But you're looking into it?
Yes.
Okay, thank you.
We would encourage you to try and save it, is what he's saying.
Right.
Replace it with lime roots.
Okay.
The laurel oaks only live about 50 years, too, so it's...
Kind of short hitters. Yeah. Any other questions? Okay, I'll open the public hearing. Would anybody out there have anything to say? No? Public hearing is closed. Gentlemen?
I move to adopt as presented by staff.
I'll second.
We've got a motion and a second. All those in favor, please say aye.
Aye.
Opposed, like sign. Passes unanimously, it sounded like. Okay. Thank you all for coming. Next item, Commissioners' Matters.
I might have to end up there somewhere.
We all are.
I'm looking for my shade tree, right? Commissioners' Matters. Planning Matters. Mr. Keating.
A few things. It's early in the new year, and already the Board of County Commissioners has been real busy and considered several items that you had made recommendations to them on. On Tuesday, they approved the amendments to the Public Nuisance Ordinance, Chapter 973, consistent with what y'all recommended. We are, pardon me?
Not all the things.
And you said you all. I just said not all.
The majority.
The important ones.
I think, as you remember, that ordinance is going to reduce weed height maximum from 18 to 12 inches. It's also going to apply our nuisance criteria to multifamily.
Big size.
The board also approved the changes to 910 concurrency, and this is changing the what we call the pending ordinance criteria that was in there for a while, and actually allowing vesting earlier than building permit time, and allowing a 3-year vesting period. So y'all had recommended approval of that to the Board of County Commissioners, so they approved that. The board also approved the changes to the Point West conceptual plan. And you probably know that mining is a controversial issue. You may remember the hearing that you had on it. Well, the board had a similar one Monday evening that none of us enjoyed. And the board at that time did vote to put in place the mining moratorium, and they accepted all 4 of your recommended exemptions. Those are in the mining ordinance. Now, I've got some good news and bad news about that. The good news is the moratorium's in effect. You won't see any mining site plans for 6 months. The bad news is, at the mining moratorium public hearing, I was asked a question, and I told the board that we would be coming to them at their meeting on January 15th, which is this coming Tuesday, with a recommended process or procedure for us to deal with the mining regulations in this 6-month period that we have to do that. And the bad news is, we're going to recommend that the Planning and Zoning Commission be the lead group that essentially works with staff to come up with the new mining ordinance criteria. I just had Stephen distribute to you a copy of the staff report that we're going to be presenting to the board.
Not the one I just threw away, Steve?
We're going to be presenting this on Tuesday. We're not sure what the board's thinking is. As you can see in there, we identified there are really three big picture alternatives to go forward. We could either have this process be pretty much a staff managed process, or it could be a process managed by one of the committees that we have, either P&Z or PSAC, or it could be the Ag Advisory Committee. And alternatively, the board could create a separate task force. And our position is the most efficient way to go ahead is to use an existing committee. And we also noted that the Planning and Zoning Commission is the committee that deals with land development regulations, land use issues, sand mining site plans.
You volunteered us.
So I volunteered you. And you can see in there, we've put in some general thoughts regarding the process and how it's going to go along, and some suggestions to look at certain issue areas and have discussions that are limited to those issue areas so that we don't reinvent the entire wheel every time, that we have some focus. So we'll see what the board does on Tuesday. We're pretty optimistic that they're probably going to concur with staff's recommendation. And then there is a lot of work to do in that 6-month period. And actually, don't think of it as 6 months. The regulations need to be in place in 6 months, so the heavy lifting has to occur really in the first 4 months. And you'll see in the staff report that we kind of have a trigger point about 4 months into the process whereby there's going to have to be a report to the Board of County Commissioners as to whether we're at a point where we can go forward with a set of proposed revised regulations, or we need to look at extending the moratorium. So basically there'll be a lot of work. You'll be much more expert at sand and rock mining when this is over, whether you want to be or not. What we're going to look at is mostly, I think it's going to be looking at a lot of material and staff reports and issued papers that staff develops, experts that we can bring in to address some of these categories.
They'll take this up Tuesday?
Tuesday.
So we have till then to lobby against this?
You do.
Okay.
You do.
You want George there for the hearing, though, right?
So there would be funding for Dr. Bacchus to come down?
Actually,
or how are you going to handle that?
Actually, that's a good question. There was a meeting today of the Agricultural Advisory Committee, and that issue did come up. Bob Adair brought that up, and that committee voted to recommend that the Board of County Commissioners bring Dr. Bacchus here for a presentation. So we'll see what the board does on that, but we will certainly notify you and invite you and hopefully work her into this entire process we have.
I have a question regarding that. If we have Dr. Bacchus here, will we also have somebody to balance out?
Right.
So that I hear both.
That's an excellent point, and that was brought up at Ag Advisory Committee that if she's going to be here, there really needs to be some of the hydrology experts from the Water Management District or some people who have the expertise to ask her the questions to challenge.
Balance it out.
Yeah.
Will the state? Will we have? What about under the criteria with the state and rock mining, which is only a part of this? But I mean, are we going to have anything from the state? Any
Margarita ought to
officials?
be here from St. John's Board of Management. She'd be a good addition to this.
And I am sure we'll have a lot of their resource people, but I think you all know, I'm not sure, that the legislature last year addressed sand and rock mining, and they actually put in place they passed a bill that was referenced at your meeting here that requires local governments, before they adopt any significant regulations or put a moratorium in place, to consider state comments. And we actually notified the state and got back some comments from the state. There is a strategic aggregate task force that's going on right now.
Report February 1st?
Yes. Yeah, actually Stan Bowling went to the initial meeting of that task force over in Tampa right before Christmas. There's a meeting this week in Miami. There are a couple more meetings, and they do need to submit a final report to the legislature by February 1st. So we'll have some more information. We're pretty sure we can get a lot of resources from some of the things that other local governments are doing. This issue is not unique to us. It's happening all over the state. There are a lot of local governments that are critically looking at their mining rules right now.
Okay. Attorneys matters, George? I'm sorry.
Bob, included in that discussion Monday, I tried to very quickly read this, but is there also a consideration of the areas in the county where mining will be allowed in the future, as well as the...
Mm-hmm. There is, but Will Collins at the beginning of the moratorium public hearing, I think, made some real important points, and one point was that the focus of the moratorium shouldn't be on prohibiting mining in certain areas, because that would subject the county to potential lawsuits and potential damages.
Like spot zoning?
Well, essentially it would subject us to a potential Bert Harris action. I think what Will's position is, and it's what staff's position is, we really need to look at all the potential impacts of mining and see how we can address those impacts by having mitigation activities rather than prohibiting mining in certain
But if you have something like hydrology or water issues in an area it doesn't have enough water, we could, if the rules may prevent mining in that area just by the rules themselves, couldn't it?
Oh, I think you're correct. I mean,
I'm not sure how you mitigate all that, and that's something I hope to learn. But
right, I think if there's a significant adverse environmental impact that would occur, that's different. But I think Will wanted to really make the point that the whole process seems focused on the Wild Turkey Project. There were a lot of people that during the hearings were talking about making sure that never came about, and that the focus really of this whole effort is to try to mitigate.
We have a lot of different mining all over the county, so I mean that's what I understand the purpose to be. So.
Well, Will had a really excellent opening statement. We ought to get a video of that and play it to everyone that didn't hear it, because that was a really, really exceptionally good opening statement he made.
Okay, gentlemen, ladies, anybody?
I had just one question on the going back to the ocean problem. They took down some trees and some violations there, and you were going to assess a fine for them. Did that ever happen?
Yeah, and what they didn't take down trees, they moved them around. I think they were all palm trees, and what they did was they moved them around on site without our authorization. And what we did is we did work out a penalty. They had to get after the fact permit, and they had to do some additional mitigation, and they did need to pay a fine. It wasn't a significant amount. It may have been $500 or something like that. But yes, that was resolved.
That was resolved?
Yes.
Okay, we'll try one more. Anybody else? We're adjourned.
Thank you.